Good morning. I'm Robert White, Council Member at Large and Chair of the Committee on Housing. Today is Monday, March 18th, 2024, and we're meeting in room 500 of the John A. Wilson Building. The time is now 9:38 a.m., and I'm calling to order this public hearing. Today, we're meeting to discuss 6 measures, 3 bills that amend the Rental Housing Act of 1985, 1 bill that amends the housing assistance for government employees, and 2 reappointments to the Rental Housing Commission. First is Bill 25-417, the Rental Housing Commission Fair Opportunity for Appeal Amendment Act of 2023. Landlords and tenants sometimes have disputes about issues within the Rental Housing Act law, such as rent increases on rent-controlled buildings. When a dispute happens, parties can take their claims to the rent administrator at the Department of Housing and Community Development or to the Office of Administrative Hearings. The losing party can then appeal the decision to the Rental Housing Commission. This measure, introduced by Councilmember Bonds, makes procedural changes to that process, such as giving more time to parties to appeal and giving more time to the Rental Housing Commission to issue its final orders or final decisions. Second is Bill 25-418, the Voluntary Agreement Abolition Amendment Act of 2023. Under DC law, housing providers can negotiate with tenants to set parameters around rental rates, building improvements, and other services in a building. The resulting contract is called a voluntary agreement, which must be formally filed with the rent administrator. The council has heard concerns about the impact of voluntary agreements on the district's supply of affordable housing and on tenants' rights. One example is voluntary agreements that promise building improvements for current tenants with no rent increases to them, but with a rent increase for future tenants. Relatedly, some housing providers have said they need voluntary agreements to make building renovations financially viable. This results in a trade-off between improved building conditions and the long-term affordability of the district's housing stock. Because of the concerns raised, Council passed a 2-year moratorium on voluntary agreements in December 2020 and has since extended the moratorium until October 1st of this year. The bill we are discussing today would, if it were passed, make the current moratorium permanent and abolish voluntary agreements altogether. The third is Bill 25-633, the Certificate of Assurance Repeal Amendment Act of 2023. Under DC law, housing providers can apply for a certificate of assurance entitlement that would supposedly allow them to obtain real estate tax credits that cover the difference in income between fair market rents and rent stabilized or rent controlled rents. The concept has never been fully operational due to issues with implementation. In fall 2020, the council passed a moratorium on this practice, which the council has extended ever since. This bill would make the moratorium permanent and abolish the certificate of assurance entitlement. Fourth is Bill 25-536, the Home Purchase Assistance for 911 and 311 Call Takers and Dispatchers Amendment Act of 2023. The district's Home Purchase Assistance Program has supported thousands of residents with interest-free loans and closing costs assistance to buy their first homes. The district also has an Employer-Assisted Housing Program, or EHAP, EHAP, that gives money to government employees to help them buy their homes. Councilmember Allen introduced this bill along with several colleagues to expand the definition of first responders under EHAP so that 911 and 311 operators can also qualify for the support. The goals of the legislation are to encourage home ownership and to improve staffing numbers at the district's call centers. Accordingly, the measures require a 5-year service commitment to receive and keep the funding. The final measures on the agenda are 2 appointments to the Rental Housing Commission. As I mentioned earlier, the Rental Housing Commission serves as an appellate body for Rental Housing Act cases. If a tenant or landlord disagrees with a decision made by the rent administrator or by a judge at the Office of Administrative Hearings, they can appeal the decision to a panel of 3 judges that sit on the Rental Housing Commission. The commission also finalizes annual rent increase adjustments for the district's rent stabilization program or rent control and makes sure Rental Housing Act regulations are up to date. Today, we will review measures regarding 2 of the 3 judicial positions on the commission. First is the proposed resolution 25-639, the Rental Housing Commission, Mr. Adam R. Hunter Confirmation Resolution of 2024. Mr. Hunter currently serves as the acting chairman of Chief Administrative Judge of the Rental Housing Commission for the district. This measure would appoint Mr. Hunter to chairperson of the commission for a term to end on July 18th, 2025. According to the materials submitted by the mayor, Mr. Hunter is a Ward 7 resident, has been on the commission since April 2022, and brings with him several years of experience in trial practice, litigation, mediation, and teaching. Without council action, the resolution for his appointment would be deemed disapproved on May 29th. Second is proposed resolution 25-663, the Rental Housing Commission Lisa M. Gregory confirmation resolution of 2024. Ms. Gregory currently serves as a member of the Rental Housing Commission. This measure would reappoint her for a term to end July 18th, 2026. According to the materials submitted by the mayor, Ms. Gregory is a Ward 2 resident and has been on the commission since January 2018, most recently serving as interim chief judge and chairperson for about 2 years, beginning in April 2022. The materials show Ms. Gregory's experience working in other government agencies, including the DC Department of Transportation, as well as serving as a law clerk to judges both locally and internationally. Without council action, the resolution for her appointment would be deemed disapproved on June 12th. Our committee sent standard written questions to both nominees and have now received those responses. I look forward to hearing more from the nominees today, as well as from public witnesses on each of the 6 measures. I want to acknowledge that both the Rental Housing Commission and the Department of Housing and Community Development are submitting written testimonies for the record regarding the 4 non-appointment measures. DHCD Director Green and Rent Administrator Lauren Pear will not be testifying in person today due to immovable conflicts. Because of the council's tight performance and budget hearing schedule, the committee was unable to find another time for this hearing when they could be present. The committee has been in communication with the DHCD team, who shared that they are monitoring the hearing. Similarly, acting chairperson Adam Hunter of the Rental Housing Commission is testifying for his appointment and submitted written testimony on behalf of the commission. We will hear from Ms. Gregory as well. As we get started with our first panel of public witnesses, I think we'll have 3 panels of roughly 5 people. I want to explain the ground rules. Everyone should have received a copy of the witness list on Friday, which is available on the council's hearing management system website. I'll call witnesses in the order on the list. When I call your name, staff will promote you to on the Zoom from attendee to panelist. When you're promoted, you'll drop out of the hearing momentarily and come back in on the panel. You can then unmute yourself when it's time for you to speak. For witnesses in person, please come to the table in front of me when I call your name. Public witnesses will have 4 minutes to testify, and advisory neighborhood commissioners will have 5 minutes. Our first panel of 5 public witnesses will be Yesem Sayan from the Executive Director of the DC Policy Center, Harry Garau, resident who is joining us virtually, I believe, Mel Zond, supervising attorney with Legal Aid DC, Catalin Peter, Vice President of Government Affairs for AOBA, and Dean Hunter, President of Small Multifamily and Rental Owners Association. Give us one moment for to get the folks who are joining us virtually queued up. And Yes, welcome. You can begin your testimony.
Thank you. Thank you so much. Good morning, Chairman White and the members of the Committee on Housing. My name is Yeşim Sayın, and I'm the Executive Director of the DC Policy Center, an independent, nonpartisan think tank advancing policies for a strong, competitive, compelling, and vibrant economy in the District of Columbia. I'm grateful for the opportunity to testify today. I will focus my comments on Bill 25-418, which is the Voluntary Agreement Abolition Amendments Act of 2023. This bill would abolish voluntary agreements, which have been, as you have mentioned, Chairman White, on hold the last 2 years. We believe that on balance, this will harm tenants and housing providers. Voluntary agreements allow housing providers and tenants mutually agree on a rent increase that's greater than what's allowed under the rent control laws, in return for agreed upon improvements in services or amenities available to tenants. 70% of the tenants must sign the agreement before the provider can submit the petition. We asked the committee to consider the following facts. First, voluntary agreements are rare. We obtain a list of all voluntary agreement petitions from the Department of Housing and Community Development for the years between 2006 and 2028. This list shows a total of 235 petitions over these 12 years with 88 approvals. That's the equivalent of 20 applications per year and 7 approvals per year. To put this number in context, there are 3,258 multifamily rental apartments. This means the petition rate is just about 0.5% and the approval rate is just about 0.2%. Second, voluntary agreement petitions are almost always filed for older buildings, presumably in need of repairs. We were able to match 117 of these petitions to the publicly available information on building characteristics. And we found that only one was built after 1966 and only 10 were built after 1955. So these tend to be older buildings, much likely to need repairs. Third, the buildings that have petitioned for voluntary agreement tend to be small. Of the 188 petitions for which we can find building unit size, 144 had fewer than 25 units, and 172 had fewer than 50. Fourth, buildings that have petitioned for a voluntary agreement tend to have high vacancy rates. Across the 188 petitions for which we had information on vacancy, we found that for every occupied unit, there were 1.6 vacant units. In other words, collectively, the vacancy rate in these buildings was 62%. 20 out of the 235 buildings with voluntary agreement petitions since have converted into condominiums and co-ops. We do not have information whether these have been acquired through top-up, but most likely the housing provider had to sell because the rents were not covering operating expenditures. It's true that voluntary agreements have received some bad press, but they have also made investments in older, smaller rent control buildings with high vacancy rates possible. Lenders will be more interested in lending to buildings with higher operating incomes, and voluntary agreements signal that operating incomes would increase. The opportunity of being able to adjust rents, obviously with support from the tenants, when it's necessary to update amenities and services in a building, keeps investors interested in rent-controlled buildings and keeps housing providers interested in owning them. Without voluntary agreements, most of these buildings would be converted into condominiums. Voluntary agreements are the clarion call for a failing building. Without them, the building will largely convert into something else, most likely more expensive. I urge the committee to consider these facts before making a decision. And I'm happy to answer any questions you might have. Thank you.
Thank you very much. Harry Garrell, welcome.
Yes, thank you. I'm Harry Garrell. I'm the president of the Van Ness South Tenants Association, representing the residents of 3003 Van Ness. I'd like to thank you, Councilmember White, for holding this hearing. I'd also like to thank committee member Matt Fruman for his work on behalf of residents of Ward 3. I'd like to speak briefly today in support of the Voluntary Agreement Abolition Amendment of 2023, introduced by Councilmember Nita Bonds. I worked closely with Councilmember Bonds to end the rent concession scam by which some rental housing companies violated the district's rent stabilization law and overcharged their customers. It's likely that tens of thousands of residents were overcharged by tens of millions of dollars. While the rent concession scam has stopped, most DC residents who were overcharged have not received restitution. The district's rent stabilization law is a critical tool for slowing the growth of rent increases in the city. It limits annual rent increases in buildings constructed before 1975 to the rate of inflation plus 2%. For seniors, it limits it just to the rate of inflation. Rent stabilization is not the same as old-style rent control, although many people confuse the two. Rent stabilization does not freeze rents at absurdly low levels, but it slows the year-over-year rent increase on an individual apartment. Rent stabilization is a much more moderate mechanism than old-style rent control. Rent stabilization is a critical tool for making housing more affordable in the district. It's a critical tool for slowing gentrification, and it's a critical tool for helping seniors be able to age in place. Nevertheless, rent stabilization has been under assault in the district in recent years, and voluntary agreements are a way of weakening rent stabilization. One of the greatest threats to rent stabilization is the law that enables landlords to negotiate so-called voluntary agreements. In theory, this is supposed to allow landlords to fashion an agreement with tenants which they swap one thing for another. For example, somewhat higher rents for a fitness room. However, it has been used as a loophole to circumvent rent stabilization. It's a way for rental housing companies to make their properties more profitable by making them more expensive. As a result, voluntary agreements make housing less affordable. Often, the corporation that owns the rental property achieves the goal of higher rents in the long term by negotiating a short-term deal with current residents. This provides a small gain to current residents, but long-term future pain to future residents. It circumvents rent stabilization by way of a private negotiation in which a landlord holds all the cards. The problem I have witnessed in our building at 3003 Van Ness is that the owner, a $24 billion real estate investment trust, is extracting high rents from tenants while it refuses to do routine maintenance on the property. Doors to the building are almost always broken. Security lights don't work. Electrical outlets in the apartments don't have required safety mechanisms to prevent electrocution, etc. And it's not because there's no money to be made in this building. It's because it's being extracted year after year, and the property owner is not putting aside money for routine maintenance, which could be done easily. This is an extremely profitable company. Rental housing companies should put aside money for a rainy day, just as ordinary families do. The DC Council has had a moratorium on voluntary agreements in recent years. The moratorium should be turned into a full repeal of the voluntary agreement language in the DC rental housing law. I strongly recommend and ask for your support for the Voluntary Agreement Abolition Amendment Act of 2023. Thank you.
Thank you very much. Catalin Peter. Is Mills on here? Can't remember. 1 second. I'm trying to remember my order.
Is this on?
Sorry, Catalin. 1
Okay.
second. Mel's on is with us. Mel, welcome. You can begin your testimony.
Thank you, Councilmember White, and thank you to the council member and your staff. My name is Mel Zond. I'm a Ward 5 resident and a supervising attorney in the housing law unit at Legal Aid DC. Legal Aid provides free legal services to low-income DC residents. Our housing practice works to preserve stable, affordable housing for DC tenants. Thank you for the opportunity to participate in this hearing. I'm here to support passage of both the Voluntary Agreement Abolition Amendment Act and the RHC Fair Opportunity for Appeal Amendment Act. Legal Aid supports the permanent abolition of voluntary agreements. Landlords have used voluntary agreements to increase rent beyond what rent control would ordinarily allow. Landlords often seek these agreements after they have threatened tenants with extraordinary rent increases. When landlords realize that the current tenants in the building might have legal arguments to defeat these rent increases, they often make the current tenants in the building an offer they can't refuse. The current tenants agree to higher rent increases, but the higher rent increases will only be charged to future tenants who don't live in the building yet. Once tenants agree to this scheme, the landlord has every incentive to push the current tenants out so it can charge those higher rents to future tenants. Sometimes this looks like landlords actively filing for eviction against the tenants. Other times, the landlord will simply let the building fall into disrepair and force tenants out through neglect. Voluntary agreements shift the cost of rent increases onto future tenants who aren't in a position to fight them. They sometimes make entire buildings unaffordable. An analysis by Legal Aid and CNHED of these agreements that have been filed since 2006 found that voluntary agreements alone have resulted in average rent increases of $964 per month per unit for 5,135 total units. To protect rent control, voluntary agreements must be permanently abolished. We also support passage of the RHC Appeal Act. This bill increases the time to appeal a rent administrator or Office of Administrative Hearings decision from 10 days to 30 days. A 30-day deadline is more appropriate for this kind of decision making, and it brings it in line with the time for appeal in other areas of DC law. In many cases, the party considering an appeal isn't an individual, but a tenant association. Tenants associations must engage in significant coordination to decide whether to appeal. Association bylaws often require members to vote on legal strategy decisions. They must give significant notice of the vote, and their bylaws ensure that they can establish, and their bylaws also must ensure that they can establish a quorum at any meeting. The current 10-day appellate deadline is so short and the procedural hurdles so great that some tenants associations may not be able to appeal at all, even when they have a valid basis to do so. Even when the party is an individual tenant, 10 days isn't sufficient time for many individuals to decide whether they should appeal. Some tenants may need time to seek advice from a lawyer on whether an appeal is appropriate for them. Importantly, tenants will only get the full benefit of this additional time to appeal if the rent administrator or Office of Administrative Hearings sends clear and accurate notice of their appeal rights, which historically hasn't been the case. In addition, the requirement in this act that the rent administrator or Office of Administrative Hearings submit the complete record to RHC within 30 days of receiving an appeal will facilitate a fairer and more efficient appeals process. Currently, cases before RHC can take years. Ensuring that the record is timely transmitted to RHC is one necessary step to make sure these cases are decided on a reasonable timeline. Legal Aid urges the Council to pass both the Voluntary Agreement Act and the RHC Appeal Act.
Thank you very much. Catalin Peter, welcome.
Good morning. This is working?
Yep.
Okay. Good morning. My name is Catalin Peter, and I'm the Vice President of Government Affairs for the Apartment and Office Building Association of Metro Washington. With regards to our multifamily portfolio, our members manage approximately 109,000 homes, creating communities throughout the district. Today, I would like to focus my comments on the Voluntary Agreement Abolition Act and the Certificate of Assurances Abolition Act. I ask for a little leeway in my oral comments, and we will also be submitting written comments. With regards to both of these bills, our members were caught by surprise in the sense that an abolition bill was put forward on both of these tools. It's our understanding that when the moratoriums were put in place, they were put in place because of COVID. For example, with regards to voluntary agreements, there's the requirement that 70% of tenants must sign paperwork, and that COVID made this not possible because people were not doing things in person. So our understanding thus far has been that the reason for the moratoriums was simply not policy, it was more administrative. That being said, now we have gone, I believe that we can confidently say that we are past those COVID era administrative issues. So when we saw that the voluntary agreements and certificates of assurances were up for permanent abolition, it certainly caught our members by surprise. I would agree with all of the comments or all of the information that was put forward by the Policy Institute. Our understanding is that the amount of voluntary agreements that have successfully gone forward has been rather small and focused on those buildings that really need the repairs the most. Additionally, I've heard language surrounding that, voluntary agreements will make housing unaffordable for low-income tenants in the future. My understanding is that those who are receiving rental assistance would still, if they're of lower or moderate income, they would still receive the same amount of assistance, that this is not necessarily something that's means tested. So I can go into that in my further comments, but I heard something along those lines. So I would question that. With regards to certificates of assurances, Our members, approximately 45 of our members have applications pending. The district had stalled in issuing those certificates, then created the moratorium, which it's since extended, like you stated. The current law does provide that if the right to exemption is removed for those properties, the district must pay annually to those property owners the difference between what the units would rent based on the market value versus whatever the rent control limitations are imposed. We're also uncertain whether this would affect existing loan terms, because when those buildings were permitted and built, loan terms are based very specifically on what the law is at the current time. So our initial concern that we heard from our members on that is we still have 45 applications that are pending, and these were put forward in good faith when the law was current. So for now, I'm going to pause my comments here. I think that we would like to better analyze the data that was put forward by the Policy Institute. We would support looking at the current voluntary agreement process and seeing if we could make it even better. I think that there are a lot of very, very pricey requirements being put on property owners in terms of building performance energy improvements. We think voluntary agreements could actually be a really useful tool in making those improvements. So for now, that is it. We'll be submitting our written comments as well. Thank you for the opportunity.
Thank you very much. To this panel, oh, Dean Hunter, you are on this panel. I need to get it together this morning. Dean Hunter, welcome.
Good morning, Council Member. I'm Dean Hunter, the president of the Small Multifamily and Rental Owners Association, a trade group representing the interests of small multifamily and other small rental property owners in the District of Columbia. I want to thank you for holding this hearing, Council Member, and we're here to speak in opposition of these voluntary agreement ban. Council Member, I'm here today to ask, not only do you let this bill die in committee, but that you introduce and pass emergency legislation as soon as possible to restore voluntary agreements. The reason is because the ban itself, the moratorium, has caused harm. The reality of the matter is that our rent control laws have come about as a result of legislation, litigation, deliberation, and experience. It didn't just come about by magic 8-ball and throwing legislation against the wall. But over the course of the last few years, prior to your ascension to the chairmanship, the council has legislated housing policy in just that manner. They've made it up as they go along. And they have nitpicked and dismantled elements of our rent control laws that are very important, to the point where they have caused harm. They have had an adverse impact on the availability of affordable housing, particularly naturally occurring affordable housing. Why? As you know, buildings subject to rent control are old properties, right? They're 1974. These properties, 50-year-old properties, need renovation. They're harder to maintain. They don't last forever. Look at all the government buildings that have been torn down and rehabbed during that period of time. The problem is you can't do that with a residential property that's subject to rent control because, one, the rents are so low, no lender is going to give you the money to renovate it because you can't pay back the loan with the existing rents. Two, you're subject to TOPA, so you can't just, unlike a government building, or kick everybody out and renovate the building and make it all market. You can't do that. So voluntary agreements are one of the few mechanisms available to property owners and to tenants to renovate and improve old, dilapidated housing and make it current, right? For example, my church owns a property over on Vermont Avenue, 40 units. The building's 50-some years old. All the systems are falling apart. The church entered into an agreement with the tenants to say, hey, voluntary agreement, we're going to come in, we're going to let everybody come back at their existing rent. We're going to double the size of the building. We're going to make it half market and half affordable. That's a win-win for everybody. Now these tenants get to move into totally renovated apartments in a neighborhood that's been gentrified, where they're seeing luxury condos all around them, right? And they're living in old, dilapidated housing. That's gentrification. So what this bill would do is say, oh, you know what? You old people, you live in that dilapidated housing. You landlord, you continue to be unable to renovate that housing. And the harm has occurred. After the end of the pandemic, when we had this moratorium, we saw a number of properties sold, right? So these properties were sold And because voluntary agreements were banned, the new owners could not acquire them, could not enter into the agreement that requires 70% of the tenants to agree. 70% of the tenants to agree. Tenants that have free representation, free lawyers, a tenant advocate that has a $7 million budget. 70% agree. There's no tenants here today who are saying, oh, we're upset with our voluntary agreement. Where are they? There's none. There's no data to support eliminating voluntary agreements. You know, I'll tell you the history of this bill. This measure was included in the radical rent control bill that was discharged by Chairman Mendelson from the Housing Committee. That bill was so disruptive to the housing community that Chairman Mendelson discharged it, and two of the members that introduced it were no longer on the committee. So what they did, they came back and introduced individual components of that radical bill. And this is one of them. This is one of them, the ban on voluntary agreements. We need voluntary agreements restored because it harms tenants and it harms owners. You got people living in these dilapidated buildings where the rents will not afford the renovations necessary, where the banks will not loan the money because the rents will not cover the loans. And this is the only way that the landlords and the tenants can improve their properties. Again, there's no tenants here complaining to this, right? No tenants. And then we talk about future tenants. So what are we saying? We're saying that people who live in old, antiquated housing right now should suffer there because of some hypothetical future tenant. This is nonsensical. This is outrageous. We need to restore voluntary agreements right now. This ban is causing harm, Councilmember. Thank you.
Thank you very much. All right, let me move into some questions. Ms. Sayin, you, at the beginning of your testimony, you mentioned that voluntary agreements are rare. Do you know why they're rare, or have any guess as to why they're rare?
I think the 70% requirement for 70% of the tenants agreeing is a difficult thing to accomplish. That's one of the reasons why you see these agreements move easier for buildings where vacancy rates are really high. But that's sort of like, it makes it easier to agree on the agreement, but it also makes it even more necessary because in buildings that are experiencing 40–50% vacancy, the income for the landlord will never be sufficient to, fix the front door or the security lights, as Mr. Grahl was mentioning.
One of the things, and I'm going to pose this question to other panelists, one of the things that concerns me about voluntary agreements is that tenants are negotiating with a landlord. And when you negotiate an agreement or a contract, usually there is both sort of a cost and a benefit to each side. For voluntary agreements, I don't see what cost falls on the current tenants. They are negotiating against future tenants. So how do we draw fairness in this for future tenants?
What is the future tenant?
Well, I'm going to start with Ms. Sayin. I'm coming to you, Mr. Hunter. I know you got some thoughts on this.
Yeah, I mean, that's a really important concern. I think one of the things that limits the landlord from using this to increase rents is just the market, right? Especially now we're seeing increasing vacancies. So the limit that the landlord has is what the market is commanding. And the negotiated rents cannot go beyond that because tenants will find some other place to live with equal or comparable amenities or location and things like this. Especially these days, this is more likely to happen because we're seeing a downward pressure on rents because of the vacancies.
Okay.
May I?
Yes, let me just make one point. The issue about the market and demand, when you look at the increase of housing costs, rent costs, compared to increases in incomes, they are very lopsided. The cost of rent has risen in the District of Columbia much higher than incomes have risen. And so we're creating a situation where housing is becoming more and more expensive, and it's not going down just because of demand. Let me go to Dean Hunter, and then I'll come to you, Catalin.
Thank you, Councilmember. If you know, maybe it's because I'm an old man who's lived in the district since the 80s, but when I hear future tenants, future residents, I hear white tenants, I hear white residents. The reality of the matter is that these buildings primarily are old properties. They're small buildings. They're naturally occurring affordable housing, and they're lived in primarily by people of color. Most of them are owned by people of color. The reality of the matter is that they're surrounding them. They have all the gentrification, right? The new properties aren't subject to rent control. So you got new properties built next to these old properties that are run down, and these tenants who are stuck here because of their income have to live in antiquated and inferior housing. This offers a mechanism for those tenants who live here right now to enjoy the benefit of the economic development that is occurring in their community. You know, what is a future tenant? What is a future tenant? The reality of the matter is we're creating more affordable housing by allowing that owner to enter into the agreement with those tenants to renovate that property. That property is still an old property. That property is still a small property. Even if you double a 20-year-old building, it's still not going to have the rents of these high luxury apartments. So it's still not going to have the amenities of these high luxury apartments. So we're creating more affordable housing. And again, this mechanism didn't come out of thin air, although we've eliminated out of thin air. We've eliminated out of thin air. And there are this whole thing about future tenants, to me, it just doesn't make any sense. Again, where are the tenants who have engaged in voluntary agreements who are here right now protesting this? The cost to the existing tenant is an improvement in their life and their quality of life.
That's not a cost, Mr. Hunter. That's a benefit.
The benefit to the benefit to the current tenant is an improvement in their quality of life. And a voluntary agreement doesn't mean a tenant doesn't have to pay. You know, they could agree to a higher rent even on their unit if it's necessary, and some have. Again, this was abolished without any evidence. This was abolished on just anecdotal data, which we're dealing with right now. Future tenants, it's causing harm.
Okay, so you spoke to benefits of the current tenant. You spoke to benefits of the state of housing, but you sidestepped the future tenant. I mean, future tenants are people who will need to find somewhere affordable to live. If you tell me, you know, I can pay $10 for my lunch, or the next person behind me can pay the $10, look, it's going to be the person behind me every day. So I get that it has been done. I don't see the logic to it, nor do I see the fairness for future tenants. So naturally occurring affordable housing ceases to be affordable if the person before you agreed to a rent increase that didn't harm them at all.
The rent increase isn't so high that it's prohibited from people living there. Again, we're still dealing with old buildings, right?
I think Melzan said that the average increase was almost $1,000 per month. Is that right, Mr. Zahn?
Yeah. Oh, I apologize.
Let's see the data.
Was that directed at me?
Yes.
Yes, that's correct. The average rent increase for these units was $804 per month per unit. And that's going back actually to 2006. So we can imagine in today's dollars, we might be seeing, if these voluntary agreements were to take place again, much higher rent increases. It also impacted 5,642 units across the district, which is obviously extensive, resulting in total rent increases of 5,000. So the units impacted was 5,642. And the total rent increases, if you put that all together, is $5,824,226. So it's 5.8 million roughly. So it's very significant cost.
Thank you.
You're going to hear from landlords today, and I dare you to find one of them who's going to tell you they've increased their rents $1,000. I'd like to see that data. Additionally, I want to know, does it include rents that are generated because of additional units added to these buildings? And Councilmember, that's part of what happens. So you take an old building like the one in Foster House, it's 40 units, you now make it 80 units. So you now have those 40 units still there. Okay, there's no harm to future tenants. The future tenants get to live in the new 40 units that are subject to rent control rates still. And then the new tenants are going to move into these new units that are now made available and that are going to be naturally occurring and still affordable because they're still part of an older property. It makes sense. There's no harm. The harm is banning them. And I'd like to see that data, Mel. Thanks.
Ms. Peter.
A lot more has been said since I last wanted
Sorry
to
about
make
that.
a comment. My greatest concern right now is our current housing stock. The operational costs are exponential. We have our maintenance staff, people who are working in these buildings, who are working tirelessly to improve them, to keep them improved, who are running against roadblock, against roadblock, against roadblock, because they cannot operate these buildings. And that is speaking from, I want to be very clear, AOBA represents both the operational side of things. Yes, we do have members who are also involved in ownership and who are involved in development. I primarily lean towards the operational side of things when I'm speaking today, but the other option, if they're no longer operational, there's no longer funds to keep them operational, is to potentially sell those buildings, like what was said before, is to turn them into condominiums. If you're defaulting on loans and you're no longer able to take additional loans to make improvements, our capital market was very different before the pandemic. The amount of access to liquid capital to make improvements was vastly different. We can provide data on that. We can provide information on that. I do understand your concern on future tenants. I would proffer to say that the council is nimble, and that if in the future our housing landscape changes again, then those are things you can look at. You do have that ability, I think, each year from time to time. However, right now we have a current crisis, and we have, like Dean mentioned, we have older properties. Seniors, they don't have the ability to move. They are not as nimble. And having the opportunity to have those buildings improved can make a massive difference in their current quality of life.
Harry Garau, you mentioned in your testimony that voluntary agreements are a way to make housing more profitable. What Catalin Peter and couple others have suggested is that this is a means to cover operating costs so that buildings don't become dilapidated or more dilapidated. How do you come to the conclusion that this is about profit as opposed to covering the cost of operating housing? You're muted.
First, let me just respond to Dean Hunter's comments about what he calls rent control. It's rent stabilization. It's not holding down rents at absurdly low prices.
Mr. Garau, I don't want to allow cross conversations.
It's related to this. So actually, the property owners have the ability to maintain their properties because the rents are not as low as that they say. In this case of our building, there's 625 units. The income on that building is close to $1 million a month, and still we don't have security lights fixed, and that's not because there's not enough income. Councilmember White, you put your finger on it exactly. Voluntary agreements pits current residents against future residents, and as long as the landlords can buy out the current residents with a relatively low sum, they'll increase rents on future residents well into the future. It is a pro-gentrification system. So voluntary agreements is making rents less affordable in DC, and they should be abolished.
There's interest in both sides of making gentrification arguments. So you believe in your building, Mr. Garau, that the owner has enough to cover operations. Do you have reason or data to believe or conclude that this is true of other buildings that are seeking voluntary agreements? How do you determine that this is about profit as opposed to covering the cost of operation?
Well, I don't know the specifics of other buildings to tell you the truth. I deal with my building. But I know that some of the owners of these buildings are gigantic corporations. Ours is a $24 billion company. I don't see any problem with covering the maintenance on our building, but I'll have to have others speak to other buildings. I think Mr. Zahn has had some excellent data that comes from their report. You may want to speak more with him.
Mr. Zahn, I was going to come to you next to see if you have thoughts on this question, whether this is voluntary agreements are about profit or the cost of operating buildings.
Councilmember, I'm not sure I can answer that question at this time. I think it probably varies building to building. I'm certainly happy to provide the full suite of data that we're looking to. What I can say, though, is that these are resulting in significant rent increases across the district, and that these voluntary agreements are externalizing costs onto residents that aren't currently in the building. There are, of course, other methods for landlords to take extraordinary rent increases in order to address operational costs. Voluntary agreements are not the only way for landlords to do that. They can do that potentially with hardship petitions, with other kinds of extraordinary rent petitions. So this simply eliminates this one path that externalize costs on future tenants without actually getting to the merits of whether or not operational costs require these rent increases.
I'm a long way out of law school and my contracts class. Our voluntary agreements are our contract. Is that right, Mr. Zahn?
Yes, I believe that's an appropriate way to think of them. Yes.
What is the cost or detriment to the current tenants who signed that agreement?
The way they're operating right now, I don't really think there is one in the agreement itself. However, what concerns me actually most of all is that once tenants have signed voluntary agreements, what we have seen in practice is that landlords then have every incentive to force those tenants out and to replace them with higher paying tenants. We see that both through active eviction cases and also sort of through neglect of the earlier rent controlled units that as they fall further and further into disrepair. So that's a practical matter. I think that cost does exist. It's just not written into the contract per se. I think the way these were envisioned when they were passed was the idea was the current tenants themselves would pay increases for renovations, extra amenities, stuff like that, but that's simply not how they seem to be functioning.
Do you have data, or
no,
Mr. Hunter, do you have data, Mr. Zahn, that you can send on evictions post voluntary agreements?
I'm not sure if I have that exact data. I'll go back through the analysis that we have and see if we have that available. I can say it's something that we've seen in practice at legal aid quite frequently, but I'll go back and look to see if I have any data. Question.
Thank you. I'm going to go to Ms. Peter and then to you, Mr. Hunter.
Sir, I would say that that's highly subjective, that our eviction laws and our current rental housing law structure is that is highly subjective.
Mr. Hunter?
I'm going to go as far as say it's not true. If that was true, Councilmember, there'd be dozens of tenants here right now I was evicted after my voluntary agreement. There'll be dozens of tenants to say my building, these people are making this up. The one tenant who's here lives in a building in Upper Northwest. I'm looking at his apartment. It doesn't look like the old dilapidated housing that my members own. They're not corporations. They're not multinational billion-dollar corporations. These are individuals who own small buildings. These are the buildings primarily subject to rent control that cannot operate without voluntary agreements, and they're used with TOPA. They've been primarily used with TOPA, right? A lot of times you have a building sold, so part of the TOPA agreement may include a voluntary agreement. So the building is sold, the new owner comes in, makes the renovations, makes any additions. It's been a win-win-win. There's not one tenant who has come to you to say ban voluntary agreements who's been harmed by voluntary agreements. And if you want to talk about benefit, then why have TOPA? I mean, what's the cost? What's the cost to a tenant to get TOPA? It's a benefit. The benefit is that they get to live in affordable housing. They get the opportunity to acquire their building. There's no downside to voluntary agreements.
I think that's an interesting point in terms of current and future tenants, in that something like TOPA is also geared towards, the benefit is towards current tenants, and it doesn't necessarily think about, I think that's why I believe generally it's subjective.
The Does anyone on this panel have, I'm always concerned about buildings that convert from affordable rentals to condos. Does anyone on this panel have any information that can help us understand that issue and whether that's a real issue here? Ms. Sam, do you have some information?
Some information. What we did was match addresses from the data we obtained from the HCD with tax rolls. And because the data is back to 2006, you can see now the buildings that are recorded as condominiums in the tax file, but presumably at the time of the application were not condominiums, they were rental buildings. We found about 20 of these buildings over the 12-year period. And also I wanted to add, I'm not sure if you're using the same data as Mr. Zahn, but the data I'm looking at for buildings where we have information on vacancy, among those buildings that were approved for the voluntary agreements, I found that there were 1,027 vacant units and 2,518 occupied units. So if the concern is reducing the number of affordable units, again, it's very case specific because you can also find some information on how the rents increased. In some cases, the percentages are really high, but the numbers are not particularly high. For example, rents increased from $500 to $900. While it's a big percentage increase, it's not an extremely high rate. But I think the point is, even if we were to assume that after voluntary agreements, the units are gentrified, there's still preserving a significant number of units as affordable.
Ms. Sane, let me stay with you for a minute. At least one panelist has suggested here, and this has been suggested in other hearings and meetings as well, that building owners should be setting aside for major repair costs as opposed to using that as a justification for things like voluntary agreements. Do you agree that that's something building owners should be doing, and can they do that?
Yes, I remember that from the discussions in the Reclaim Rent Control Bill, because I believe it had a provision for increasing the capital reserves to a certain number. I think, building owner, again, it's an internal decision. I'm not privy to, but the owner will set aside the reserve that will minimize future risk and maximize the return on his building or her building. I'm sure there's a guideline, but I wouldn't prescribe a certain increase for every building because it's not just going to be realistic. And when your margins are low, if we are forcing the owner to do X, something else will not get done.
Right.
I think the assumption is generally that there's always money in housing providers' pockets, and that's not always the case. It's very building specific.
I was going to add that we have building energy performance standards. We have a number of requirements, a number of other legally mandated requirements in terms of improvements that need to be made, which are not always financed by the district government. So yes, those capital reserves go through all of the other things. We can bring a list of all of the other mandates and requirements that the district government does put on our building owners, again, not financed by the district.
But if you own a building, you're going to have to do capital repairs.
Sure.
If I could, yeah. If I could also add.
I'll come to you. I will come to you immediately next, Ms. Hunter.
Sure, you absolutely are going to have to do capital repairs. I would say, though, that you can't always anticipate that the council is going to pass legislation in the 20th year of owning the building that's going to require now an entirely new structure in terms of your energy performance standards or those costs. So it adds up. It adds up it adds up.
Mr. Hunter.
Yes, Councilmember, you own a building that's 50 years old. eventually you can't just keep putting Band-Aids on it, right? It requires substantial rehabilitation, requires major systems to be replaced. And you can't do that when the rents are already held below market intentionally. You can't go to a bank to get a loan. And you're not going to be able to save up enough money out of the low rents you get to totally renovate your apartment building. Again, there are no tenants here arguing against this. There's no tenants who've been harmed, not one. But you're going to hear from landlords who've used this mechanism and who have been harmed.
But if I own a house and my roof needs to be repaired, I'm gonna have to take out a second mortgage, home equity line of credit, refinance. I'm gonna have to do something, right?
Yeah.
And why is that different for the owner of a multifamily building?
It's the difference for an owner in an old building subject to rent control, because the bank's not going to loan you the money where your rents are already so low that your margins aren't enough to pay the increased price to borrow the money to do the renovations.
And let's not forget COVID.
They are renovating the buildings right now. They are making the repairs right now. They're doing it and they're barely getting by. But what we're doing by eating into the systems that have been in place that were intentionally put there to allow these providers to get some relief so that they can make a profit and maintain these properties, we're driving people out of the business and we're negatively impacting the availability of affordable housing. And we're doing it without any evidence, and we're just doing it in an anecdotal, haphazard manner. And I'm asking you to please, let's not do that here.
And COVID artificially depressed rents for nearly 3 years. So that was not anticipated. I would say that any policies that you're abolishing after COVID or putting in place after COVID, you do have to take into consideration the effect of the pandemic.
Yes, and did you have something on this?
Yes, I do. And thank you for raising that question. As someone who had to recently replace my roof, it really resonates.
Me too.
Oh my God. But I think the key difference, Councilmember White, Chairman White, is that you and I have no choice but to make that investment, because this is our home, our kids live in it, and we have to keep something over our roofs. For any business owner, whether it's a housing provider or producer of widgets, they have to make a return on their investment that's equivalent to what they would have made if they just put their money in a bank or bought 10-year treasuries and absolutely have no other headaches. You just then sit in their chair all day long. And that's the thing, that they have to make a certain return in the long run. The business have to give them something more than a return on 10-year treasury bills. And for that reason, it matters that the costs that we impose on landlords, housing providers, and therefore tenants through regulatory impositions, because they have an option, and you and I, in the short run, at least, we don't.
Right. So if the council decided to keep voluntary agreements with additional safeguards, what might that look like? Are there again, I don't understand sort of in logic, in contracts, I don't understand voluntary agreements, but they are here. I understand the purpose they serve. I just don't understand how we got here. But if we kept voluntary agreements but put in safeguards, does anyone on this panel have thoughts on what those might look like?
We do, actually, and this is why I was surprised when the bill for full abolishment came about, because we have, and I'll include those in my written testimony, we have some thoughts on additional safeguards that can be put into the current process, including energy improvement, efficiency upgrades, or certain I don't want to misuse my terms, and I'm speaking a bit off the cuff because I don't have them right in front of me. But I do believe that there are practical post-pandemic state of our current housing, thinking about our future housing, there are ways to modify the current process.
Let me just mention one other thing, because everyone spoke about just the voluntary agreements except Carol and Peter on certificates of assurance. when I read Councilmember Henderson, who introduced that bill, her introductory letter, it indicated that no one had requested a certificate of assurance until 2019, despite this law being in effect for 40 years. I don't know the accuracy of that statement, but would you be able to look into that to help us understand how, if at all, certificates of assurance had been used over the past several decades?
Yes, and that was before my time as well. And so yes, it's good information to know.
I appreciate it.
Councilor, if I
yes.
could add one thing on certificates of assurance. Well, we didn't come to testify in support of that. We do think they are important, and I can tell you historically why they came about. They came about because when the rent controls laws were implemented, housing providers said, "Hey, we're not going to build anything else in the District of Columbia." They said, "If you implement these bans on rent increases, we're not going to build." So what the government did at that time was say, "Hey, tell you what, we'll give you a certificate of assurance. We're going to say anything that was built after these rent control laws were implemented, we're not going to impose rent control on you." And it was only when this radical rent control bill came up during the pandemic, while landlords were hurting, that there was an effort to try to impose rent control on the newer properties. That's when the certificates of assurance were discovered. And that's when housing providers said, "Hey, we had this guarantee that you weren't going to do that." And that, hence we see why we're in the situation we're in right now. There was no effort to impose rent control on newer properties until the pandemic with that radical rent control bill that the council discharged. It was so outrageous.
That's appreciate it. Well, I want to thank this panel for being with us. We have a few more panels and some government witnesses. So thank you all very much. It's been incredibly helpful. We're going to move to our next panel of public witnesses: Debbie Knox, Felipe Ernst, Keith Carr, Stephanie Johnson, and Stacy Barton, president of the DC Association of Realtors. If I didn't mention an association for particular witnesses, it's because I don't have one. So I'm assuming they are public witnesses. So give us a moment to get people queued up virtually. Oh, should be Debbie Knox, one, Felipe Ernst, Keith Carr, Stephanie Johnson, Stacy Barton. Debbie Knox, you can begin when you're ready.
Good morning, Councilmember White and members of the Committee on Housing. My name is Debbie Knox, and I'm president of the National Association of Government Employees, Local R307. I'm here today to testify regarding B25-0536, the Home Purchase Assistance for 911, 311 Call Takers and Dispatchers Amendment Act of 2023. I'm here to speak to the legislation and the impact it will have for us. There are several reasons this is important to my members. One, it will permit those who wish to and can afford to live in the city to be able to do so. Two, it will expand the definition of first responder to include OUC call takers and dispatchers. What is crucial to us is how we are identified and seen by those citizens we serve. On February 28th, 29th, 2024, the National Emergency Number Association, NENA, held its yearly 911 Goes to Washington event. Nearly 400 911 emergency communication leaders from 40 states and territories descended upon Capitol Hill to advocate for the funding for Next Generation 911 and for reclassifying the 911 occupation as protective service, not clerical. Next Gen 911 will help emergency communication centers replace the analog 911 infrastructure to the Internet Protocol IP-based system. In short term, it will create a faster, more resilient system that will allow voice, photos, text messages, and videos to flow seamlessly from the public to the 911 network. We are the first responders. And being the first responders of 911, we should be identified as such, protective service. For over 30 years, I've seen men and women with whom I've had the honor and privilege to stand alongside of handle many crucial calls for service. When I was hired, I took an oath to serve and to protect, just as my then counterparts of the Metropolitan Police Department had done. Even though the OUC, with whom we work for, is being criticized for many mishaps, that is not our story. We have and will continue to be that beacon of hope for those who work, live, and play in our nation's capital. Thank you, Councilmember White and Allen, for basically developing the legislation, and the counterparts on the Housing Committee for realizing how critical we are in the public safety cluster by initiating this legislation. By the council passing this piece of legislation and the mayor signing off, our road to our proper classification and the ability for my members to become homeowners in the nation's capital should be that much closer for the taking. Thank you.
Thank you very much. And Felipe Ernst, welcome.
Hello, Councilmember White. Thank you so much for taking the time to listen to the public on these important topics. And I am here to talk about the voluntary agreement and kind of I know what's at stake here, where they want to get rid of it permanently. And I think that this would be a huge mistake for the District of Columbia. So if we could just look back. Obviously they put a halt on the voluntary agreement during COVID. You couldn't form a quorum, people couldn't get together, which made a lot of sense in that, they wanted to pause kind of a process that required 70% of a building to be in agreement. And obviously with COVID, you couldn't have people come together. So it made sense that they paused that. But now, the real beauty of the voluntary agreement is, in my opinion, is the word voluntary, right? It needs to be agreed to by the tenants. It's a win-win situation where the tenants agree, to increase their rent in exchange for substantial improvements in the building, capex improvements, renovations, constructions. Typically, obviously, to rent control buildings that require these additional investments that wouldn't be otherwise feasible if it weren't for the voluntary agreement. So, I think that the voluntary agreement, I've executed a couple of them in the past. It's always been a win-win situation for the residents that aren't interested. They don't have to elect to voluntarily agree to it. For the residents that are interested in seeing capex improvements, obviously, it plays to their benefit. But I think that as the city kind of continues to, end kind of these programs that have been around for decades and decades for a reason, it's becoming harder and harder for housing providers to operate and provide quality, affordable housing, quality rent control buildings, because a unit that's been renting for $800 a month for decades doesn't justify an investment on a new roof. And to the panel's point earlier, Robert, Councilmember White, where you said, well, if you have a new roof and yeah, that's your house, you're going to pay for a new roof. You could do a home equity line of credit. You can save up for it. But in this case, these are investments that the money needs to come from somewhere, right? And if there's no profit and there's no excess cash flow or cash to go into these improvements, then quite frankly, they're just never going to happen. And that's something that is only going to continue to spiral and make these living conditions more and more deplorable for the residents of the District of Columbia. So we need to come up with some kind of avenues to allow for investments in these older buildings that desperately need them. And to the point earlier on the safeguards, I think requiring certain energy efficiency standards, requiring certain levels of renovation to the buildings to make sure that they're brought up to code and brought up to the standards required for today within reason. But I think there's a give and take where everyone can kind of benefit from the voluntary agreement. And it's a real shame because it's in getting rid of it, it's creating less and less incentives to invest in the District of Columbia, which is only going to lead to more, slumlord-like owners coming in and just making zero improvements and zero capex investments in these buildings, which desperately need them. So there needs, it's the government can't be like, oh yeah, we're getting rid of the voluntary agreement, we're getting rid of this, we're getting rid of that, we're getting rid of the 30% rent increase, which they got rid of a couple years ago. And then it's like, okay, well, how do we make these investments that are critically needed without having avenues that were designed in order to make these improvements? So I just want to say thank you guys so much for listening to my opinion, and I'm hoping that this is something that we can improve and not just shoot down and close another avenue of making investment in affordable housing, which is desperately needed.
Thank you very much. Keith Carr.
Thank you, Councilmember White and the panel for the opportunity to speak here. I'm Keith Carr. I'm proud to be an owner and an operator of naturally affordable housing in DC, and I'm here to speak in opposition to the abolition of the voluntary agreement. I think there are two main benefits to the voluntary agreement. One being it's necessary for upkeep, as Felipe and Dean have spoken. The maintaining older stock buildings is expensive, and there are systems that need to be upgraded, if they're 50, 60 years old, and it really is the only tool to capitalize on the future equity of the building to make the improvements now for the residents that are in place. The second benefit that I see is it's really difficult to buy a stabilized building and compete with the condo developers. Mathematically, it's almost impossible without the use of a voluntary agreement. And I believe that the voluntary agreement actually keeps affordable housing in place because those buildings are not being converted into condos. It's a tool that allows operators like me to compete with the offers that these condo developers are putting forth when buildings are for sale, where those condo developers are going to sure pay the existing tenants a little more money for them to vacate, but then that housing stock is gone. With a voluntary agreement, I've been able to compete with those condo developers, maintain the building as an affordable house, as an affordable housing provider, and I've seen great success only through the use of a voluntary agreement. I've done 3 buildings with a voluntary agreement, and they're all still way below market. The 3 that we did 9 years ago. 40% of the tenants that were there when we did the agreement are still in place, while 100% of the units are still below market. So much so that when we refinanced about 2 years ago, we qualified for a special loan rate for providing affordable housing. The average increase that we took on those buildings was under $300 on the units that did turn over, while we were able to add security, add storage, add parking, and increase the services for the tenants that existed, as well as the tenants that moved in after the agreement. I can say those buildings also sit at 100% occupancy. There's a long list of people trying to come in because they are still below market. Perhaps a more thoughtful review of the voluntary agreements when they come through would help weed out the bad actors. I can only speak to my experience, which I think has been a win-win for everybody. And quite frankly, the only way that I'm able to provide that housing was with a voluntary agreement. But, I'm hearing from the panel that maybe there are some other people that have utilized the tool in the wrong way. And, I know that there was a 45-day review period. I don't know what occurred on the city side when they were reviewing, but maybe a more thoughtful review of that or a more thoughtful follow-up if people aren't keeping up their end of the bargain with a voluntary agreement. I also think it's a false presumption that the low rent units are going to go to the people in need. I definitely have plenty of tenants that don't, they're financially capable to rent a more expensive place, but happen to take the low rent because they qualify for it. So, I'm not seeing who's being protected by abolishing the voluntary agreement. I think that's all I have to say. Thank you.
Thank you. Stephanie Johnson.
Good morning, Chairman White and the committee members. I'm getting a little tongue-tied. I'm here today to offer my testimony in full support of Judge Adam Hunter's appointment as the Chair and Chief Administrative Judge of the District of Columbia's Rental Housing Commission. I have known Judge Hunter for nearly 2 decades. We met as classmates in the same section at Howard University School of Law. Since that time, he has been a team partner, co-counsel, business partner, colleague, and dear friend. It is due to his reliability, professionalism, and legal acumen that I have continually chosen to work with him at nearly every phase of my own legal career. I'm elated to be before this committee today to testify not just because he's a valued friend, but because he is best suited for the role. Judge Hunter possesses the qualities necessary to make an efficient and effective leader of the Rental Housing Commission. First, he has a long-standing working knowledge of the landlord and tenant laws of the District of Columbia, which are unique from many other jurisdictions. During the time we owned our own law firm, he handled the majority of our landlord and tenant cases that often resulted in favorable results for our clients. Next, he's fiscally responsible, trustworthy, and organized. While we had an equal partnership during the time we owned our law firm, Judge Hunter handled all of the finances. His fiscal acumen allowed our business to grow exponentially over the years. It was his foresight and knowledge that curated a marketing strategy that made our growth possible. He also ensured we made all filings and payments timely related to the operation of our business. I could always rely on him to handle our financial matters. I was also able to review our finances at any time as he kept excellent records. Furthermore, Judge Hunter possesses the temperament and skills necessary to be a fair judge. He is deliberate, compassionate, and able to analyze legal issues holistically. For these reasons, he has always been able to get the parties to come to an agreement in our civil cases, which ultimately saved our clients thousands of dollars in litigation fees. He possesses a special talent that allows him to truly see all sides of an issue and then come up with a solution that is manageable for everyone. His keen legal knowledge, combined with his unique ability to solve complex and contentious issues, makes him well suited to lead the Rental Housing Commission to make important decisions related to the housing of our city's residents. Lastly, Judge Hunter has shown a consistent and vehement dedication to this city and its residents. Judge Hunter attended Howard University for both his undergraduate degree and his law degree. He has been a resident of the District of Columbia for over 20 years, living in both the Northwest and Southeast quadrants of the city. As a student at Howard University, he often volunteered for philanthropic efforts in the city, and he taught students at Eastern High School's constitutional law and oral advocacy skills through the Marshall Brennan Constitutional Literacy Project. Judge Hunter continues his philanthropic efforts today by sitting on numerous boards for the nonprofit organizations in the city and volunteering at a church east of the river that offers a weekly food drive for low-income residents. Moreover, Judge Hunter has zealously represented the indigent people of the district charged with crimes to ensure that they are treated fairly and justly in the criminal legal system. Thus, his dedication to this city and its progress is longstanding and indisputable. The Rental Housing Commission would be fortunate and should be honored to have such an exceptional individual leading it to ensure the integrity of the district's officials and government. I thank this committee for their time and for allowing me to share my thoughts about Judge Adam Hunter.
Thank you for being with us. Stacy Barton with the DC Association of Realtors.
Good morning. Thank you for allowing DCAR to be here to share our feedback. Excuse me. DCAR represents over 3,000 members, and we are the voice of real estate professionals, housing providers, small housing providers, homeowners and renters who live and work in the District of Columbia. First, we are testifying in opposition to the Voluntary Agreement Abolition Act of 2023. Voluntary agreements are an important and necessary tool, especially for small landlords, that allow landlords and tenants to enter into an agreement in order to upgrade building services and facilities and make capital improvements. The result is a win-win for both parties. These agreements also promote community buy-in, which we should be encouraging. Other than voluntary agreements, housing providers can petition the same upgrades and capital improvements without the tenant's say. However, this can often lead to rifts between landlords and tenants and ultimately end up in arduous and lengthy judicial proceedings. It is essential to note that steps have been taken to address specific concerns raised about voluntary agreements. First, the Rental Housing Commission decision on the Feynman versus Smith Property Holdings Van Ness LP ensures that property owners cannot arbitrarily inflate the price they would otherwise be able to charge for a unit, which would also extend to voluntary agreements. Second, as Acting Chief Administrative Judge Adam Hunter advised in his written testimony, the RHC has adopted new rules that would continue to address the concerns of DC tenants and tenant advocates. However, due to the current moratorium on voluntary agreements, these new rules have yet to be implemented. Rather than abolishing voluntary agreements altogether, we would strongly suggest allowing the implementation of the new rules and reinstating the voluntary agreements. Second, DCAR is pleased to support the Home Purchase Assistance for 911 and 311 call takers, Dispatchers and Amendment Act of 2023. Our members applaud this legislation as it provides multiple benefits that will have a positive and lasting impacts for Washington, D.C. In addition to supporting homeownership in the district, This bill will help encourage 911 and 311 operators to move to DC, which is desperately needed to help mitigate the challenges that residents have been facing and experiencing when they call for emergency services. While we understand the budget constraints DC will face this year, we want to encourage the council to prioritize funding for this program in addition to existing homeownership programs offered in the district. We would also like to ask the council to ensure that the process for the program participants is efficient and clear. It has been our experience that when clients attempt to participate in existing programs, they often face challenges with navigating the prescribed procedures. Limited guidance, funding, and complex requirements leave program participants feeling lost. It would be counterintuitive to create such a valuable program only to have limited participation because of bureaucratic and procedural challenges. Finally, we want to thank Councilmember Allen's office for reaching out and seeking the insight of the realtors. Our members are always happy to share their perspectives and aim to help the council shape common sense legislation that will help advance homeownership and make DC a coveted city in which to live and work. We are eager to answer any questions you have on how this legislation may impact the district, real estate professionals, and residents. Thank you.
Thank you very much. I have fewer questions for this panel. Let me start with the rental assistance bill, the employer assisted housing program. I agree both with Ms. Knox and with Ms. Barton about the importance of this program and that it should be administered well. What I'm bracing for, and I think we should all be bracing for, is a very difficult budget year. I suspect that we're going to see cuts to every or virtually every program. And so we will have to understand, how we navigate any changes in the existing legislation with the amount available and the already high demand for these programs. That said, I think it is important to make sure to the highest extent possible, all of our employees and very much our 911 and 311 call takers that play a very important role. It's an agency that still needs a lot of stabilization, and to have a stable agency, you need stable residents or stable employees. So my hope is that we can get there, but we're going to have to, we're going to be constrained by the budget. On voluntary agreements, let me go first to Mr. Carr, who I think owns multiple multifamily properties. How many did you say you had negotiated 3 voluntary agreements recently?
That's correct. It wasn't recently though. It was 9 years ago.
Okay. All right. What's the most common reason that you've used voluntary agreements?
Really, it was to be able to compete to purchase the building. I mean, we were competing against people whose strategy was to, clear it out and convert it into condos. And it was the only way that we could sort of mathematically compete with the purchase price, was to lever the future equity, make the improvements, and then, win the bid. These 3 buildings actually came through the TOPA process. So the tenant selected us as the purchaser, and the voluntary agreement was the tool that allowed us to essentially collaborate with the tenants to buy the building.
Okay, so you work with the tenants. You told them if you purchase the building, you would do a voluntary agreement and make certain changes, and the tenants opted to select you as the purchaser?
That's correct.
Okay.
And the TOPA agreement and the voluntary agreement went hand in hand. Otherwise, we were not mathematically competitive to buy it.
What were some of the improvements that you agreed to make?
Sure. So we installed new kitchens in virtually all the units. Some tenants, I think there were 3 or 4 that didn't want the kitchens. We installed new security system, fob access, cameras around the building, which was important. We put a rear patio for the tenant. The tenants wanted to be able to grill and stuff behind 2 of the buildings. We put patio back there for them. And then we were able to upgrade the laundry room facilities for them as well.
Okay. So that those are wonderful amenities for the residents. In your testimony, you suggested that these were win-wins. What about future tenants? What I think you spoke about the rent increase for future tenants. What was that?
So I was in the panel, I was trying to do is kind of back of the napkin accounting of what the average increase was when the tenants did leave. And, 40% of the original tenants are still in place. 60% have left. And of the 60% that left, the average increase was a little under $300.
And is that
Sorry, go ahead.
and that is an average rent? Is the increase in 300, is that in like the first year? Is that throughout their tenancy?
That was the average jump when we went from an existing rent and we took the voluntary rent increase.
Got it. And what were the rent increases in years after that?
They structured by CPI, so it was either the allowable rent increase or less, depending on the tenant's situation.
Okay. And what do commercial building owners do when they need to make major systems upgrades?
So, I own a few, and I'm here, testifying as an owner, but we also have a third-party management company that, we have some owners that have owned naturally occurring affordable housing for, decades. And part of the problem is that they're not necessarily cash flowing very well under rent control, and they're okay with that. But when they come to needing to put in a new roof or, you know, potentially deal with some of these new environmental regulations, like trying to put solar in or deal with their water runoff, they don't have the ability to go to a bank and get, sort of the equivalent of a home equity line of credit or refi. So, I do have a lot of owners that have been forced to sell those buildings. And, unfortunately, the past 2 years, they've been sold almost exclusively to condo developers because there isn't a source of funds to make those major renovations.
If you have contacts of a couple of folks who have sold buildings who would be willing to talk to the committee, I would appreciate it. I'd like to understand how they made those decisions. Appreciate it.
Yep. Happy to.
Thank you so much. And Felipe Ernst, you've done some voluntary agreements as well, is that right?
That is correct. We've done a few of them in 2015, 16, 17 in those years, which allowed to doing, adding sprinklers to some of the buildings, adding air conditioning to some of the units, and making material improvements. Without the voluntary agreement, quite frankly, it wouldn't have been possible. And to Keith's point, a lot of the time it happened concurrent with the TOPA process, which allowed for these buildings not to go the condo route, especially in these up and coming neighborhoods that, condos were shooting up in value. So yeah.
And I've asked similar questions to others, but why could you not have made these? So these were all of yours done in connection with TOPA agreements?
Correct. That's correct. They were done during the acquisition period. And to Keith's point, we wouldn't have been competitive in the acquisition process if with the existing rents to justify making these capital improvements. Because quite frankly, there just wasn't enough money to make these investments.
With the other competing offers, were they convergence to condos? Were they other ownership entities?
Yeah, they were other investment companies, and they could buy these buildings, vacate them, and convert them to condos. They could sell these things for $600, $700, $800 a foot and permanently remove these options from kind of affordable housing, let alone the rental pool in DC. So the voluntary agreement was, quite frankly, the only tool available. in order to compete with these, condo developers. And the beautiful thing about it, Mr. Councilmember White, is that the tenants had to agree, right? Like all of this is done voluntarily, and that's the beauty of the voluntary agreement. If the tenants don't want to see the improvements, don't want to participate in a voluntary agreement, they just say no. And it is what it is. But to make these improvements with having the tenants as partners is what makes the voluntary agreement such an incredible tool, and something that we're hoping to utilize in the future to preserve more affordable housing and to make the necessary improvements like sprinkler system. Now the DC government is creating more energy efficient. We need to have energy efficient buildings that are going to be tracked on an annual basis. And quite frankly, unless the government is providing grants or basically free capital to make these investments, you can't justify that from a rent control unit that's renting for $800 to $1,000 for a 2-bedroom in Columbia Heights. It's just, the money's just not there. Like, it's not reasonable to expect a private citizen to make an investment out of their own pocket if they could put that money in a treasury and make a 5% return tax free or whatever it is. So we need more avenues to make these improvements, ideally through the voluntary agreement and through other government programs. I know money's tight right now with the government, but it's becoming more and more cumbersome to make the required investments that we all want to make. But quite frankly, financially, we just can't.
I appreciate it. Ms. Johnson, I don't have any questions for you. I want to thank you for your testimony on behalf of Judge Adam Hunter. Debbie Knox, I don't have questions for you. I want to thank you for being here on behalf of NAGE and employees, and mentioning obviously the important work that our 911 and 311 call operators do. So thank you very much to this panel of public witnesses. We have one more panel that will include Armande Gill, President of the Park West Tenants Association, Dean Smothers, and I'm not sure if any of these people are here, Dean Smothers, Sean Weingast, Steve Jerry, Frank Avery, Commissioner Frank Avery, who I believe is here. Excellent. Right. Commissioner Avery, I think you're the only person on this panel. Welcome. You can begin your testimony. No, sorry, your name.
I'm here about the voluntary agreements.
Steve Jerry. Excellent. Well, Mr. Jerry, welcome. You can begin your testimony. My apologies.
I'm a owner of small buildings in the district. I have done a voluntary agreement in the past. I have several low-income units in the district. It's a very difficult market. The council has done a lot of legislation that has basically made units at the bottom, cost-wise, not economical in the city. If we want to have low-income housing, we need to have conditions where it can exist. Voluntary agreement is, one of the tools in light of very, very stringent tenant laws in the district to actually get improvements done on a lot of these properties. Without it, the one we did, you have tenant agreements, voluntary agreements, as well as, hardship petition, and then you can gut the place and turn it into condos and sell it. Well, when we did the math on a hardship petition, we found that where we would end up after, several years of wrangling about it would be that the rents would be at market. Hey, great. But we ended up doing a voluntary agreement. So we ended up with still below market rents. But, people want to ignore this, but you cannot sustain an apartment that's renting for $200. It can't be done. It's not realistic. And we need to be realistic about housing in the district. Our current scenario is that the overlapping laws and tenant protections all work together to make, I mean, maybe double the cost of a low income unit. You have someone not pay the rent, it takes a year to evict them. Where does that money come from? Like, we need a more mature approach to our housing in this city, or else we simply won't have it. I think it's very ironic that legal aid is concerned about future tenants. They're, public enemy number one in keeping future tenants from existing by destroying the conditions where you can have low income housing.
Whether you can have what, I'm sorry?
Low income housing.
Okay. I appreciate your testimony. Do you have any concerns about the cost of rent for future tenants or affordability for future tenants as a result of voluntary agreements?
I believe that that's determined by the market. If you're able to rent places and those people exist there to rent them. When we try to, rewrite the market with the legislative pen, we're not, we're mortgaging the future for right now.
I understand your point. What it doesn't seem to take into consideration is issues like displacement. There is a wide gap between average incomes based on race in our city. It's no secret that we've had massive displacement, people call gentrification, over the decades. That's something the market doesn't control or correct for, which is one of the reasons legislators step in. What impact, if any, do you think we should be considering on displacement?
In a purely, economic standpoint, little. But as an individual, as a citizen, it is something to be concerned about. We have gone so far with, you've had years where you can't even keep up with inflation. How are people going to come in and buy buildings and invest in buildings where, if the council will kind of come back later and say, oh yeah, we're not going to keep up with inflation, that's not a proposition that will result in housing. Housing costs are high. We need more housing, not less. But when we make it so difficult and so skewed, 12 months to get into court for non-payment, this is the system that we have, making it more strict, giving it yet more layers of overlapping inability to just realize what is happening economically and in our market and in the industry is not really a solution. It's a short-term Band-Aid. We need more housing in the district, not to wildly increase the costs of existing housing. Of course, I've gotten a little bit off track as we are here about voluntary agreements. For our experience was, we had a place, I think it was generating $2,000 a month in rental income from all units, a small building. But, even right now, we still have wasn't for mortality, we would have, 75% of those original residents. And, I'm a little different from some of the folks who are testifying today in that, like, when your water heater breaks, I show up,
Mm-hmm. Commissioner Avery, this is going to be our last panel. Yeah, you can join. When you say you have done successfully completed voluntary agreements, okay. What was the reason for those voluntary agreements?
Well, I think I mentioned the building was generating $2,000 in income a month, which is not very much between 6 units. So, do you think a building can be maintained with that?
Well, I don't know how you define income, so I'm just trying to. That's one of the reasons.
Revenue.
Okay. Total or beyond operating costs. So are you including any operating costs in that?
No, that's revenue. Revenue is before you include operating costs.
Okay. How long did you own the building before the voluntary agreement?
Maybe 5 months.
Okay. So you bought a building and this, it's not a criticism. I don't own a building, so I'm trying to understand. So if you buy a building where it's clear the rent will not cover operations, what's the plan if the voluntary agreement isn't successful?
Hardship petition,
Okay.
which
So,
I think
but
stipulates a 12% return. When we ran the numbers, that would raise rents to about 1,100 for 1 bedrooms, 1,300 for the 2 bedrooms.
okay.
Our average there is less than that today.
When was the voluntary agreement?
6, 7 years ago.
Okay.
And actually, it's funny, I got a call from one of the ladies who's there now. She's on the 3rd floor. She'd asked me if she could move down to a vacant apartment on the 1st floor, but given the district's rent control methods, there isn't really a way to do that. Maybe we could do a voluntary agreement to enable this little old lady to move down to the 1st floor, but if they don't exist, that can't happen. And then we are, in fact, bidden by the fact that that 1st floor unit has, turned over several times and is now at market. And so we can't trade that for her unit unless we can do something with the paperwork, but that doesn't exist as a mechanism.
Yeah.
So while my initial inclination, I know all my residents pretty well, my initial inclination is to accommodate people. It's currently rendered impossible by city law. Little old lady just wants to move down to the 1st floor.
Commissioner Avery, welcome.
Yeah, thanks for having me, and apologies for the delay. I miscalculated a little bit in terms of the timing.
No problem.
Sure.
You can begin your testimony.
Yeah, thank you so much. Well, first of all, my name is Frank Avery. I'm the commissioner for single member district 6B01, which for those not familiar is the small neighborhood that wraps around the house side or the south side of the Capitol complex. And I am also vice chair of ANC 6B's Public Safety Committee. And I am here on behalf of Advisory Neighborhood Commission 6B with their full support to express our support for Bill B25-536, the Home Purchase Assistance for 911-311 Call Takers and Dispatchers Amendment Act. This legislation addresses one of many possible solutions to close a significant talent shortage faced by the Office of Unified Communications. ANC 6B, through its Public Safety Committee, has been tracking a number of issues that are challenging the OUC on an ongoing basis. A recurring concern, and one that I've personally experienced, is the long wait times and repeated errors when processing emergency calls, often cited due to low staffing. While this bill does not resolve all of the issues directly, it does signify an essential move as part of a holistic approach to resourcing the OUC by aiding in recruitment and retention efforts for them in terms of talent and acknowledging the indispensable role that high-performing OUC staff perform as fellow first responders. By extending the Home Purchase Assistance Program to include 911 and 311 call takers and dispatchers, we are aligning them with other first responders, such as the Metropolitan Police Department and DC Fire and EMS personnel, recognizing their vital contributions, unique occupational hazards and traumas, and encouraging long-term knowledge, commitment, and participation as members of our community. ANC 6B recommends the DC Council adopt this legislation as part of a more holistic approach to resolving the ongoing public safety challenges in our community, and specifically, the ongoing challenges of the Office of Unified Communications. Incentives to hire, train, and retain OUC personnel who live in our communities is a small but positive step towards enhancing public safety by ensuring the stability and efficacy of OUC's staffing plan. The Council's action to adopt this bill would mark positive progress in our collective efforts to safeguard the well-being of our community. Thank you so much for considering our support.
Thank you. We had a couple of mentions of this bill in the previous panel. I'll generally repeat what I said there. I think it's a good bill. I think it would be very helpful, particularly for an agency that we need to focus on stabilizing. I have a lot of concerns about what will be available in the budget. The reality is that either people will get less help or fewer people will get help. But we need to look at this anyway in the context of an agency that is very important to our public safety ecosystem. So, Commissioner, I appreciate you and your colleagues for testifying about this. I will say, Mr. Jerry, one of the points that somebody made in an earlier panel, the cost of operating buildings is the cost of operating buildings, and I like to see I'd like to see a reality where we have capital reserves that can cover these costs, so we don't have voluntary agreements. I recognize that's not where we are, and that we have to be conscious of the possibility of conversions, because when affordable buildings convert into condos, we permanently lose that affordable housing. And where the margins are thin, generally the larger corporate entities will be the only ones left who can purchase those. And I don't think they tend to operate in the best interests of residents as compared to smaller landlords. This is a generalization, but broadly, I believe that to be true. So this is not a simple issue, and it is one that we hope to get right, or as right as possible. So appreciate you coming today to add your perspective as well.
Right. Thank you.
Thank you very much to all of our public witnesses for being with us. Incredibly helpful and insightful conversation on a number of tricky issues. We're now going to call up our two Rental Housing Commission nominees, Judge Adam Hunter and Judge Lisa Gregory. The committee is hearing from these nominees today, and the commission has submitted its testimony on other legislation separately. Before you sit down, I'm sorry, Judge, it is the practice of this committee to swear in government witnesses, which you both are, so I would ask that you raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Housing is the truth, the whole truth, and nothing but the truth? Thank you very much. You may provide your statements when you are ready. Do you all have a preference as to who goes first? Judge Hunter.
Thank you. Good morning, Chairperson White and council members. My name is Adam Hunter. I am proud to appear before the commission as the nominee for chairperson and chief administrative judge of the Rental Housing Commission. First, I'd like to thank Mayor Bowser for the opportunity to serve this city for the last 2 years on the commission, and for the confidence to lead this commission as its chairperson and chief administrative judge. My work on the commission and my ability to serve this city, which I love, has been one of my greatest professional achievements. I also like to thank this committee and Chairperson White for holding this hearing on my nomination. As you know, the Rental Housing Commission serves 3 key roles in implementing and enforcing the Rental Housing Act of 1985. First, the commission acts as a specialized intermediate appellate court, hearing and deciding cases between housing providers and tenants where one or both parties are appealing a ruling by the Office of Administrative Hearings. Second, the commission determines and publishes the annual rent adjustment of general applicability for rent stabilized units. Third, the commission is charged with issuing, amending, and rescinding regulations to implement the Rental Housing Act. The Rental Housing Commission is one of the district's newest independent agencies, gaining its independence in 2019. The commission has a small staff comprised of 8 full-time employees, including 3 administrative judges. Since my time on the commission, I have participated in hearings, drafted decisions and orders, oversaw status hearings, and worked closely with other administrative judges and staff with publishing new regulations and the annual rent adjustments. I have learned how the commission functions as part of DC government, its interplay with the Office of Administrative Hearings, and how the commission serves the residents of the District of Columbia to ensure that they receive a fair hearing and a fair ruling on the decisions of their case. I want to address with the committee my qualifications for the role of chairperson of the Rental Housing Commission. I meet the technical qualifications as I am a DC barred attorney in good standings, admitted to practice law before the District of Columbia Court of Appeals. I'm a proud Ward 7 resident for the last 5 years, I am neither a housing provider or a tenant. By way of background, I've spent the majority of my professional career as a trial attorney. My main practice areas were in civil litigation and criminal defense. I'm a proud graduate of both Howard University, where I received my Bachelor of Arts in Economics and Political Science, and Howard University School of Law. During law school, I taught constitutional law at both Eastern Senior High School and the Youth Services Center. I've been an adjunct professor of trial advocacy at Howard University for the last 7 years. I've also been a board member of Rising for Justice, a legal services organization that represents DC residents in both civil and criminal matters. Prior to my initial confirmation to the commission in April of 2022, I ran a small law firm for over 11 years. The workings of a law practice is similar to the day-to-day task of leading a legal team, support staff, and working alongside judicial colleagues. Knowing how to manage a caseload, staff, budgets, and the administrative task are analogous to the work of a director of an agency that operates as an intermediate appellate court. Substantively, I represented both landlords and tenants for 13 years. I began my work on tenant matters during my 3rd year in law school, where I represented DC residents in landlord and tenant court through the legal clinic DC Law Students in Court, which is now known as Rising for Justice. As a member of the civil clinic, I represented and advised DC residents facing evictions. I litigated housing violations with landlords and advised tenants of their rights during their initial court hearings. I was successful in reaching settlements with landlords and holding them responsible for their housing code violations on behalf of DC residents. In private practice, I advised clients on landlord and tenant laws and regulations, registering rental properties with district agencies, drafting and reviewing leases, and advising clients on court procedures and processes. I litigated hardship petitions, tenant petitions, represented and settled DCRA matters on behalf of landlords before the Office of Administrative Hearings. The majority of my landlord clients were small owners with less than 4 units. My litigation experience representing both landlords and tenants gave me a strong foundation to be a fair and observant judicial officer. All jurists must commit not only to upholding the Constitution, but to valuing the process where all perspectives are heard, evaluated, and respected. Jurists have an obligation to challenge each side on the facts, legal basis, and reasoning. They also have the duty to look at past legal precedent, the facts that are presented on the record, other persuasive authorities, and the arguments from the parties when ruling on a particular case. This jurisdiction strongly favors matters being heard and decided on their merits and not just disposed of on mere procedural grounds. I would like to continue in that practice where parties will receive a fair hearing on facts of their case and receive legal and just decisions that fairly enforce the housing regulations. When drafting written decisions, I will continue to strive to use language and phrases that the average DC resident will be able to understand and follow so that they may know, understand, and value how their government is ruling on their case. If confirmed, my goals as chair will be to decrease the amount of time it takes for cases to be resolved, make the online access to RHC decisions and case dockets more user-friendly, and continue to educate the public regarding our function as a commission. The commission will also be a place where pro se litigants will have the resources and plain language documents to understand our appellate function, its process, and its rulemaking authority. As the chief administrative judge, I will conduct and oversee hearings fairly and impartially. I want to continue the quality and thoroughness of our decision-making. our appellate review success from the DC Court of Appeals has stood for the last 6 years without a reversal. We take this as the best evidence that the commission is serving its most important function, doing justice for the parties before it. I am prepared and ready to lead this commission. This concludes my testimony, and I appreciate this opportunity to share a summary of my education, training, and skills. And again, I thank you for your consideration. I'm available to answer any questions.
Thank you very much. Judge Gregory, welcome.
Good morning. Good morning, Chairperson White and members of the Committee on Housing. I am Lisa Gregory. Thank you for considering my renomination as an administrative law judge with the Rental Housing Commission. I'm excited by this opportunity, and I'm here today to discuss my qualifications to serve another term on the commission. Before I begin, I would like to thank Mayor Bowser for putting forth my reappointment. I'm grateful to Mayor Bowser for her confidence in my ability to serve our city's residential rental housing stakeholders and her effort to improve affordable housing in the district. As you know, the Commission enforces the Rental Housing Act of 1985 as amended in 3 ways. We decide appeals brought to the Commission from tenant petition and housing provider petition decisions and proceedings before the Office of Administrative Hearings and the Rental Accommodations Division. We issue, amend, and rescind regulations which enforce the Act. And we certify and publish the annual Consumer Price Index rent adjustment of general applicability, the CPI annual increase. The Commission is a quasi-judicial body that is charged with enforcing the Rental Housing Act. For decades, the Commission was a separate administrative entity within the former Department of Consumer and Regulatory Affairs, and subsequently within the Department of Housing and Community Development. Pursuant to the Rental Housing Commission Independence Clarification Amendment Act of 2017, the Commission became an independent agency on October 1st of 2019. I have served as administrative judge and interim chairman before and after the Commission became an independent body. During my tenure, the Commission achieved some major accomplishments. On December 31st of 2021, the Commission published a comprehensive revision of the district's municipal regulations that implement the Act. This is the first set of comprehensive regulations since 1985, which was published 35 years ago in 1986, and the first set of procedural changes since 1998, some 23 years ago. These changes matter. They provide much needed clarity on the rules that housing providers, tenants, judges, lawyers, litigants, and advocates are expected to follow in order to comply with the Act. When I was interim judge, I reinforced and improved the Commission's administrative machinery and infrastructure to ensure that it performed its 3 major functions more effectively. As you know, the Act requires Rental Housing Commission administrative judges to be DC residents who are not housing providers or tenants. Members must be admitted to practice law before the DC Court of Appeals, have litigation experience and knowledge of various laws, including but not limited to the District of Columbia Administrative Procedures Act, Landlord and Tenant Law, and Civil Procedure. I meet and have demonstrated all of these requirements. I'm a DC resident. I'm a homeowner in Ward 2 Shaw neighborhood. I am not a housing provider or a tenant. I'm a member in good standing and have always been in good standing with the DC Bar. I am a licensed attorney for nearly 22 years. Further, I possess years of experience with the DC Administrative Procedures Act, Landlord and Tenant Law, Civil Procedure, as well as other related areas of law. Most importantly, while an administrative law judge, The commission fully complied with its three-pronged statutory mandate. During my tenure on the commission, I have worked diligently to carry out my statutory duties with impartiality and efficiency. I have endeavored to hear and decide each case with fairness and objectivity and to render decisions that reflect the current state of the law, which are legally sound and worthy of affirmance by the District of Columbia Court of Appeals. During my tenure at the commission, I have completed 55 orders and/or decisions and orders. To date, no decision personally authored by me has ever been overturned by the DC Court of Appeal. I believe that my past performance demonstrates that I'm well qualified to continue to serve on the commission, that my dedication, diligence, and commitment to the commission warrant my reappointment. Chairman White, I know that it is a privilege to work as a public servant, and I take my position as administrative judge seriously. I'm a native Washingtonian, and I love our city. I'm inspired by and hope that I can continue to serve my fellow citizens with an even heightened degree of competence and integrity going forward. Again, thank you for this opportunity to appear before this commission today. I'm happy to answer any questions.
Thank you both. Judge Gregory, and I'm going to ask you both this question. When your questionnaires, each of you replied NA to the question about why you left your former employment positions. Can you clarify why you marked NA on that? And if necessary, update the reasoning behind leaving the positions?
Why I left my former position?
Yes.
So I served as the chief of the Civil Rights Office for the DC Department of Transportation for 10 years. And I was looking for a new opportunity. I have focused on procurement law and human rights law. And so this opportunity to serve as an administrative, well, first a commissioner on the Rental Housing Commission was attractive. And so I applied. So.
Yes, I was at the time a partner in my own practice. So I left my practice to assume this position. So that's why I left my former position. So I wasn't technically employed, but I was self-employed at that time.
Okay. And I have more questions for you, Judge Hunter, than I do for Judge Gregory because of previous employment. I just want to make sure we have conversations on the record.
Yes.
But before I do that, actually, I'll come back to this question. Let me stay on this issue. So you were formerly a managing partner at a firm. Your resume indicates that you represented and advised clients in administrative hearings before the Office of Administrative Hearings. How many cases from your former firm have gone to the Office of Administrative Hearings? Do you know?
I can't say precisely how many cases. It wasn't a huge part of my practice, but when you're doing landlord-tenant representation and you have ongoing clients, there are matters at times that touches on Superior Court, landlord-tenant court, Office of Administrative Hearing. Particularly with landlord-tenant matters, there's oftentimes an interplay between all areas. I don't have an exact number of how many cases went before the Office of Administrative Hearing.
As a judge on the Rental Housing Commission now, you decide cases on appeal from the Office of Administrative Hearings. Has anyone from your former firm represented a party that has come to the Rental Housing Commission? So have any of your former colleagues come before you at the Rental Housing Commission?
They have not. And actually, my former law partner who had testified before me, she's now working at Howard University.
Okay. And for any cases that you worked on when you were still in private practice, did any of those cases or parties move before you once you were at the Rental Housing Commission?
None. At the time in which I concluded my practice, I personally did not have any matters before the Office of Administrative Hearing that would have the ability to be appealed to the Rental Housing Commission. I do believe there might have been one matter that my firm did have open at the time, but myself and my law partner at the time in which I took this position and she moved on to Howard University, we had concluded our practice.
Okay. But that issue, to your knowledge, has not come before.
It has not. And if a matter were to come before the commission, I would recuse myself.
Okay. And as part of your work with the firm, your resume indicates that you represented and advised small businesses in contractual and real estate transactions, landlord and tenant disputes, evictions, and drafting residential and commercial leases. Since you've become a judge on the commission, have you continued representing or advising small businesses?
No, when I concluded my practice, I completely concluded representations of clients. As you may know, when you conclude a practice, there are probably still some issues that could still come back to you. But for purposes of advising clients, they have to retain new counsel on any matters that might come back. Otherwise, I do not advise clients on any cases.
Okay. And have any of those clients, to your knowledge, come before the commission?
None of my former clients have come before the commission.
And for Rising for Justice, which you mentioned in your statement, are you still affiliated with the program?
I am not. I was a board member for many years. We did have a recent case that came before the commission where Rising for Justice was representing one of the parties. It was disclosed to the other party that my former position, there was an objection to it out of abundance of caution and the preparedness of any type of eliminate any appearance of any type of favoritism. I recused myself in that case.
Okay. How many decisions have you written since you've been been a judge on the commission?
There's been one decision written. There's been about 4 or 5, I believe, orders that have been issued. All decisions that are issued from the commission get circulated amongst all the judges, talked about, edited, voted on. There have been a few procurement opinions that have come out of the commission. Over the last 2 years since I've joined the commission, there hasn't been a tremendous amount of cases that have appeared in front of us, partly because of the moratorium that happened that also impacted the work that we did at the commission and also the work that was coming out of the Office of Administrative Hearing.
Judge Gregory, how many decisions have you written since you've been on the commission?
11 decisions, a total of 55 decisions and orders. So whatever the difference is.
Thank you. And my final question for you both, and I'll start with you, Judge Gregory. If you're reappointed, what are 2 goals you would like the commission to achieve during your tenure?
So if I'm fortunate enough to be reappointed, 2 goals that I'd like the commission to achieve would be 1, to continue to efficiently and fairly decide decisions that come before us. In my estimation, that is one of the most important mandates that we have. Our body is available and it's it is pro se litigants that are often making use of our commission. And so the court, you've seen in the news where the DC Superior Court is bogged down and they don't have sufficient resources. And so even though there's a mechanism within our rules that calls for a Drayton stay, which kind of halts what's going on in the Superior Court, and gives the commission the senior position for deciding a decision. It's really important that we continue to look at the matters that are before us, make sure that our rules are made plain, look at the facts that are before us, and make sound judgments. The DC Court of Appeals, in a case called United Dominion versus the Rental Housing Commission, has said very clearly that it is the commission that sets the legal standard for rental housing in the city. And so we take that very seriously, Judge Hunter and I and Judge Carmichael. And so that's the role we play. That's what the stakeholders and the taxpayers are looking for. So how could it not be the fundamental thing that we have to get right? If I'm not speaking about that, I'm talking about our judges continuing to get trained, that we are looking at cultural competency, that we're looking at equity and impact. And so training is important. And then language access, making sure that parties that come before us that have limited English proficiency can still get due process. And then continuing to look at the rules and make sure they're keeping pace with what the council has decided. So that would be the things that I think the commission would be focused on.
Thank you. Judge Hunter, two goals you'd like to see the commission achieve during your tenure if you're reappointed.
Yes, well, one is decreasing the amount of time to get opinions out. I think it also goes back to what Judge Gregory was saying. Training is paramount, making sure our staff is up to the ability to do the work that is needed on behalf of the commission. The second thing is make sure that our opinions and decisions and our docket can easily be accessed, searched, and tracked online. Currently, we just have a basic Google Docs that have all the opinions published, but to be a true appellate court, litigants, the public should be able to put in case names, docket numbers, litigants, and their docket should completely be populated for them on the RHC website. Currently, you have to manually go through to pull out those documents. So my goal is to make that more user-friendly. And I do want to add just one third thing as a goal, and that really is to educate the public about who the Rental Housing Commission is, because there's oftentimes that the name makes people believe that we have a different function than what we are, which the function is that we are truly an intermediate appellate court. We do appellate decisions. We handle matters on appeal from the Office of Administrative Hearings, and we draft regulations. And then sometimes it's hard for the public to understand our true function as part of the DC government and how we work in regards to landlord and tenant matters in the district.
I appreciate that, and want to thank you for your service and willingness to continue to serve in these positions. Those are all the questions I have at the moment. Again, for the public's information, these are two sitting judges that the committee has worked with, and in her absence, want to thank Judge Carmichael for her work as well. I want to thank everyone who's joined our hearing today, particularly public witnesses. Written testimony is encouraged and will be made part of the official record. So if anyone is interested, they can submit written testimony to our new hearing management system, LIMS, which is lims.dccouncil.gov/hearings. LIMS, lims.dccouncil.gov/hearings. Because of the deadline for the Rental Housing Commission nominees, the record for this hearing will close at the close of business tomorrow, March 19th. If anyone watching needs more time to submit testimony on the other measures, please reach out to the committee at housing@dccouncil.gov or at 202-727-8270. If you're interested in learning more about the work of this committee, please sign up at robertwhiteatlarge.com so we can be in touch with updates. With that, the business before this committee is concluded. The time is now 11:53 a.m. and this public hearing of the committee is adjourned.